Hi, Greg Brown. The next issue in our contract series is a legal doctrine called mistake of fact. It's something that not many people know about and can really affect whether a contract will be deemed valid, void, or avoidable. And the California Civil Code gives you the definition of it as it comes. It's under section 1577. Now, what does that mean? The best way to describe it is to tell you about a case that I just worked on. And in that particular instance, the client had a contract with the broker for the sale of a $2 million piece of property. But they were also trying to lease it at the same time. So there was a second contract for a listing agreement for the lease of the property. And what had happened is that the client and the broker had a falling out, and the client wanted to cancel the contract, which, because of the term of the contract, the broker had to agree or it wasn't going to be canceled. But what happened here is the client told the broker, I want to cancel both the listing for the sale of the property, and I also want to cancel the listing for the lease of the property. And what the broker did was respond to the email right away and say, here's the proper form to cancel the listing, and didn't distinguish between the two and didn't identify that what he was really doing was giving our client just the cancellation of the lease listing but not the sale listing. So the client signs that contract, sends it back to the broker, and assumes everything's canceled. So what do? They hire a new broker who sells the property quickly, of course, and they pay a $100,000 broker's commission. Well, during escrow, then the prior broker comes back and says, well, wait a minute, I have an exclusive irrevocable listing on that, and I'm entitled to my $100,000 commission as well. So that was the issue, and actually the defense was unilateral mistake of fact, because my client thought that the broker was sending her cancellation of both sale and the lease listing and signed it believing that. Now, the broker obviously knew he wasn't canceling both and took advantage of his knowledge that my client thought she was only canceling one. So in unilateral mistake, usually what you have to have is that the other side takes advantage of you not knowing a fact or believing something is true that's not, like she believed that both the sale listing and the lease listing had been canceled, and it wasn't in fact both of them canceled. So that's the doctrine of mistake, particularly in our instance, unilateral mistake. And in our contract series, we'll talk about a few other defenses that are not well known but can be very potent and powerful in defending a breach of contract case. Thanks a lot. Bye.